Hey, moderator, this is Wesley Paulson. I have no sound.
Can you hear us, Wesley? We can hear you, Wesley.
Good morning. It's Thursday, November 12th, 2020. This is a virtual special meeting of the Commissioners of the City of Rehoboth Beach. I'll call this meeting to order at 10 o'clock a.m. Thank you all for being here and witnessing these proceedings. I'd like to do the roll call next. Commissioner Susan Gay.
Here.
Commissioner Richard Byrne.
Here.
Commissioner Jay Legree.
Here.
Commissioner Patrick Gossett.
Here.
Commissioner Pat Caluzzi.
Here.
Commissioner Edward Chernowski.
Here.
Mayor Stan Mills is here. We have a full complement of mayor and commissioners. We are able to formally conduct business. Also with us today is City Manager Sharon Lynn on the screen there. For our attorney for the mayor and commissioners is Max Walton. You also see him on the screen here. The purpose of this special meeting is to consider and decide several preliminary motions regarding the appeals of site plan approvals for site plan review application number 0620-03, Clear Space Theater, and site plan review application number 0620-03, Rehoboth Spotlight. This is a continuation of the meeting originally held on October 29th, 2020. No public comment is allowed at this meeting, as the matters to be heard relate to appeals filed pursuant to Section 236-6 of the Municipal Code, which allows only persons who have provided written or oral testimony before the Planning Commission the ability to appeal and restate their position, and because evidence and legal arguments not on the record of the hearing before the Planning Commission may not be presented. Therefore, again, no public comment is allowed. Those speakers that have registered to speak and are allowed to speak include, of course, the mayor and commissioners, Max Walton, our attorney for the Planning Commission, Glenn Mendalis, for Clear Space and Rehoboth Spotlight, Eugene Lawson, Esquire, and Wesley Paulson, and for the appellants, Marie Hatkevich, Jan Conacy, Harvey Shulman, and John Swift. Again, thank you all for being here and participating. I would like to remind everybody that our documents are all online on the city portable, so everything we're referencing, you're able to access on our online portal. I would like to give some preliminary notes, and that is we will likely need to take some occasional recesses. We will stop for a lunch break if it's needed. Timing is by our attorney, Max Walton. All votes will be by roll call, and a reminder that when we vote, we are to state our reasons for our votes. I'd also like to acknowledge that we have received correspondence in the matter of Clear Space, and it is not being acknowledged for this meeting, but is on file and will be available on the city online portal prior to the November 30th appeal hearing, if that takes place. Now I'd like to introduce you to our attorney, Mr. Max Walton, who is representing the mayor and commissioners in these matters. He will offer ground rules and help us manage the meeting. Thank you.
Thank you, Mayor. For the public's benefit, the commissioners don't act today in their usual legislative role. They act as judges of an appeal under the procedure under 236-6 of the code. I'd like to say what today is not about. Today is not about the legal merits of the decision of the Planning Commission. Those will be heard on November 30th if the appeals are not otherwise dismissed or remanded. And today is not about whether folks like or dislike the applicant. That's largely irrelevant. This is ultimately about hearing legal claims on whether or not the appeal should go forward or should be remanded. And my job is ultimately to help the proceedings go as smoothly as possible under the circumstances, but it's all, the commissioners make the ultimate decision. The motions that are being presented today, we started at a previous meeting, and we're going to go forward today under the following ground rules. Each side will have 20 minutes for argument. Due to the particular motions that are left, appellants will go first. Clearspace and Rehoboth Spotlight and the Planning Commission will go second. And if the applicants have any time remaining, they can provide a rebuttal. Following argument on each of the motions, the commissioners will deliberate and decide the motion previously presented. Mayor, with that understanding, I believe we're ready to begin, unless you have anything else.
No, thank you, Max, for that. As you know, our attorney has suggested an order for considering these motions, and I'm going to exercise my chair prerogative, and I'd like the order to change. First, we'll hear the process issue motions, then we will go on to community meeting motions, and then the remainder motions in order noted. So when the appellant is ready, we will start on the process issue motions. Thank you. Marie, unmute yourself.
Now you can hear me.
Yes, we can. Thank you. Proceed.
Thank you. Good morning, Mayor and Commissioners. Thank you for continuing the hearing today. I trust you all have had a chance to review the process failures motion. But before I get into that, I want to first put on the record that I am a ClearSpace supporter. I would like ClearSpace to remain in Rehoboth, but as a good neighbor. And for the record, this motion, as well as the community meetings, were joint efforts by the appellants as a group. They are each a compilation of the ideas of the group. They were written, edited, and finalized by the group. I am not representing, and no one in the group is doing that. Today, I am presenting the information that people in our group have asked to be passed along to you as you consider how to proceed on the appeal of the ClearSpace project. Your legal counsel, Mr. Walton, has asked that all 21 appellants not speak. And so on these issues, you'll be hearing from me, these two issues. The purpose of the process failures motion is to demonstrate how the Planning Commission failed to follow the code in a number of instances, and in others ignored their responsibility to ensure that the citizens of Rehoboth could participate in a fair site plan review process. The motion cites 8 distinct process issues, which together demonstrate a pattern of problems that compromised the decisions of the Planning Commission and resulted in a site plan review process that was unfair to the public. But because my time is limited to 20 minutes and I have essentially 8 sub-motions to cover, I will touch briefly on some issues and go into more detail on the most significant of the 8. Please refer to the motion filed October 6th for the full detail on each of the 8 motions. First, the incorrect misleading noticing of the July 10th, 2020 preliminary site reviews. I'm touching only briefly on this issue. Suffice it to say, the published notices of that meeting were incorrectly labeled as a public hearing, a virtual public hearing, and thus potentially misleading. That's a fact. You can see it in the appendix to the motion in black and white. While Mr. Mandalis termed this an insignificant issue, it is the start of how the Planning Commission failed to follow a correct and fair process. As to our second issue, the setting of the date of the public hearing, Mr. Mandalis contends that the, quote, movements seem to complain that the Planning Commission prematurely established a date for the final review public hearing of the clear space and spotlight applications. Well, I'm going to clear up that confusion. We're not seeming to complain that this happened. It did happen. Let's start with the timeline. Clearspace Theater and Rehoboth Spotlight filed their applications to the city on June 12th. At the Planning Commission's June 12th meeting, the chair noted the applications and also said that Clearspace's lawyer, Mr. Lawson, had requested, quote, an expedited review. The preliminary site reviews were then scheduled for the Planning Commission's next meeting on July 10th. The preliminary site reviews were held July 10th, and the Planning Commission at that very meeting went ahead and scheduled the public hearings for August 14th. They did that despite the fact that over the more than 4-hour discussion, a majority of commissioners, along with over 30 email and letter writers to the agenda and 7 speakers from the public, all raised issues and questions about the project, indicating that more information was needed from Clearspace. Per the code 23632H, quote, an applicant who has addressed the issues, if any, identified during preliminary review shall have its site plan placed on the Planning Commission's agenda for a public hearing and action by the Planning Commission. In his response, Mr. Mandalis bold-faced the following line, and it's worth noting here. The schedule, quote, the scheduling of this public hearing shall be at the discretion of the chair of the Planning Commission in consideration of the ongoing workload of the commission, end quote. Well, the code raises 2 problems for the Planning Commission. Number 1, the public hearings were scheduled before the applicants addressed the issues identified during preliminary review. In fact, the Planning Commission did not officially submit its, quote, comments and recommended action items to Clearspace and Spotlight until July 13th, with an addendum on July 18th. Second, in his response to this motion, Mr. Mandalis appears to be characterizing the, quote, discretion of the chair of the Planning Commission, end quote, to schedule the public hearings as a carte blanche discretion and not one related specifically to the end of that sentence, which is not a subordinate clause separated by a comma, but rather the completion of the thought. That is, quote, in consideration of the ongoing workload of the commission, end quote. Well, again, the code and the facts are clear. You don't schedule the public hearings until, quote, the issues identified during the preliminary review are addressed. And that is not up to the discretion of the Planning Commission chair or anyone for anything but consideration of the ongoing workload of the commission. Mr. Mandalis goes on to question our, quote, heavy reliance upon the site plan application instruction sheet, which, as we've noted in detail in our motions, very specifically lays out the sequence of events that need to occur and clearly cites the requirement for resolving all questions and issues that come up during a preliminary site review before scheduling a public hearing. The instructions even give examples of how those sequences of events could and should play out. Just to note, these are the instructions that have been given out by the city since 2014 for applicants to follow when they bring projects and submit applications to the city. Mr. Mandalis claims in his response to our motion that they are, quote, not legally binding and were never adopted by the city commissioners, end quote. Well, for the record, these instructions were developed and approved by the Planning Commission on March 14th, 2014, by a vote of 8 ayes and 1 abstention, and documented in the Planning Commission's report in the minutes of the March 24th, 2014 Mayor and Commissioners meeting, where the Planning Commission reported that it had, quote, reviewed and discussed the updated site plan review application form and instructions prepared by the city solicitor's firm. After several minor changes were made, the Planning Commission adopted the site plan review application form and instructions, end quote. So per the record, Mr. Mike Hoffman from Mr. Mandalis's firm was involved in the development and review of the site plan application instruction sheet, the document that we are relying on too heavily in some opinions. The mayor and commissioners were made aware of this Planning Commission approved government form, which is how it's currently labeled on the city website and available on the city website, If Mr. Mandalis's contention is that it is not a legally binding document, does that actually mean that the city has been giving applicants instructions that are not legally binding for 6 years? It's of note that on page 4 of Mr. Mandalis's response to this part of our motion, a new element and surprising element was revealed. And that is that, quote, ClearSpace and Spotlight provided additional documentation to the Planning Commission on July 18th. This was a new piece of information. That leads to 3 questions for Mr. Mandalis. First, did the Planning Commission meet to review the additional documentation ClearSpace and Spotlight provided on July 18th? According to the city calendar, the only Planning Commission meeting held between the July 10th preliminary site reviews and the August 14th public hearings was a special meeting on July 24th. And the agenda and minutes for that meeting do not reflect any discussion or review of additional documentation from, or for that matter, anything about ClearSpace and Spotlight, even though that additional documentation had been provided to the Planning Commission evidently 6 days prior to that meeting. Second question, was there another, in effect, not public meeting where the Planning Commission met, reviewed, and agreed that ClearSpace and Spotlight had addressed the concerns and questions that the Planning Commission and the public had raised on July 10th? If so, where is the documentation on that meeting? Where is the record that the Planning Commission reviewed and found the, quote, additional documentation to be satisfactory and complete in answering their comments and action items and the public's concerns from July 10th? Third, if there was no review by the Planning Commission confirming that ClearSpace and Spotlight had addressed the issues raised at the July 10th preliminary site reviews in their July 18th received additional documentation, doesn't that mean the Planning Commission was still not in compliance with the code and should not have proceeded with the August 14th public hearings? In his response, Mr. Mandalis says, all this, quote, is not important, end quote, that the movements were, quote, not deprived of due process because the public hearing could still have been held on August 14th, 2020. But again, that presumes the Planning Commission actually did a review of that additional documentation, did actually addressed it at some point after July 18th, fulfilling its responsibility to and determine if the additional documentation was satisfactory and complete. Or was
10 minutes remaining.
I'm
10
sorry.
minutes. 10 minutes. You have 10 minutes remaining.
Thank you. At some point after July 18th, fulfilling its responsibility to review and determine if the additional documentation was satisfactory and complete, or was receiving these materials in and of itself determined to be enough to check off that requirement box. Mr. Mandalis claims that while the Planning Commission may have set the public hearing of August 14th, quote, for the sake of efficiency during the July 10th meeting before receiving supplemental materials from ClearSpace and Spotlight, that discretionary action was harmless and certainly did not deprive movements of any due process. So somehow it's okay that what the Planning Commission did was not compliant with the city code because it was for efficiency. It might be suggested that a better word would be expediency, particularly given ClearSpace's lawyer's request for an expedited review back in June. Mr. Mandalis also said it was harmless, but how is it efficient and harmless to not follow the code? And Mr. Mandalis's mention of that July 18th submission from ClearSpace segues pretty nicely into the next element of our motion, and that is the inadequate time for public review of the ClearSpace responses for the Planning Commission's actions. The short story here is that the public clearly had no time to review the supplemental submissions of the applicants in advance of the August 14th public hearing. Mr. Mandalis's revelation of the July 18th additional documentation, which the public never saw, submitted to the Planning Commission by ClearSpace and Spotlight, adds another troubling dimension to this part of our motion. If the Planning Commission had additional documentation from ClearSpace and Spotlight on July 18th, why was it withheld from the public for 23 days and only finally released on August 11th, 3 days before the public hearings on August 14th? Particularly if it was satisfactory enough per Mr. Mandalis's contention that the Planning Commission could have gone ahead and still scheduled the public hearings for August 14th. Now, clearly the additional documentation ClearSpace and Spotlight gave to the Planning Commission on July 18th was not complete. At the very least, the community outreach the commission had asked to be held did not happen until July 31st. The 4-page report on that effort, as well as the July 18th additional documentation, again, was not made available to the public until August 11th, when Mr. Paulson emailed out a link to those at 11:08 a.m., just 5 hours before the 2 business days window closed. I understand it was also posted on the city website at the agenda for the August 14th meeting pretty concurrently. Furthermore, the 54-page clear space traffic evaluation report was not made available until August 12th per Mr. Paulson's 7:15 a.m. email, which was past the 2 full business days requirement. Now, Mr. Mandalis' position is that, quote, move-ins do not claim they never had access to such submissions, only they did not have adequate time to review such submissions. He says, we didn't cite any ordinance or law in support of our position, so there is, quote, no basis in fact or in law. He says, quote, clearly inadequate time to review the supplements is a highly subjective term and is not defined in the relevant code, the relevant ordinance, or the Delaware Code. But how can the public provide comment if they are not provided with the information they need to make comment, either pro or con? And remember, the city has a requirement that you give adequate notice, 2 full business days, if you want to speak or submit something to the agenda. But citizens can't expect the city to give them adequate notice on information in as consequential an issue as the largest non-hotel, non-government project to be built in Rehoboth. Unfortunately, Mr. Mandalis is right. There is no code or ordinance that says the Planning Commission has to be reasonable and respect the right of the public to be informed about and weigh in on the important projects in their city. Perhaps this is another interpretation of the Commission's discretion. How are the rights of citizens being protected when their government can ignore their need to know and prevent them from actively participating in the government that they elect and pay for? Excuse me.
5 minutes, 5.5 minutes.
I'm going to go very quickly. The 4th issue is the poor quality, unreadable drawings. I'm not going to go into all the detail I have, but the bottom line is the drawings simply did not meet the code requirement of section 236-32C to be legible. Numerous Planning Commission members, Commissioners Strange, Trunzo, and Kaufman, and Chair Perry, said they were difficult to read and they needed the required legible drawings, as did many members of the public who spoke or wrote in. The Planning Commission actually did receive the better code compliant drawings in advance of the August 14th public hearings. However, the drawings available to the public per the August 14th agenda were still the illegible ones, the non-code compliant ones from the July 10th preliminary site reviews. The next element of the process failures motion is incomplete site plans. And again, this is a quickie. Briefly, in conjunction with the drawings that were difficult, if not impossible to read, we noted that we could identify some code requirements that were not being met on the drawings. These specifically dealt with a missing crepe myrtle tree, the Mr. Crepe Myrtle, on the property line between lots 417 and 419, and the underrepresentation of a large 100-year loblolly pine near the Joseph House, all of which Mr. Mandalis said in his response to this motion would not be left standing despite Rehoboth's commitment to the tree code and its 26-year history as a tree city. For the sake of time, I'm going to jump over the 6th element, which is suppression of public comment. You can take a look at the motion and see the detail there. Finally, the 8th issue is the approval of clear space and the spotlight applications with aspirational goals. This last process failure is perhaps the most surprising of all. And Mr. Mandalis' response is pretty surprising too. In approving the clear space and spotlight applications, the Planning Commission identified a series of conditions associated with the approvals, but classified them as aspirational goals and made it very clear that they were not required. Such non-consequential conditions are not described or allowed per the code, nor are they described in the site plan application instruction sheet, where the conditions that the Planning Commission can impose on applicants are very specifically defined and defined with consequences for non-compliance. You can look in the motion and see all the quotes from the planning commissioners to this best efforts type thing. We're asking you to do the best, good faith best efforts, no consequences. Mr. Mandalis dismisses our concerns by saying that the code does not prohibit them. He questions and is confused as to why movements are offended by a proclamation's articulating how the applicants can and should be good neighbors to move-ins. He claims the aspirational goals were an attempt by the Planning Commission to strike a balance between the concerns of the public with the rights of the applicants. There is ultimately no balance without consequences because there is little likelihood such efforts will occur. And these aspirational goals were actually very good aspirational goals. They addressed many of the concerns the move-ins have. A traffic mitigation plan, buffers with the neighbors, although they also suggested putting buffers inside the neighbors' properties, sound attenuation, alternative patron parking. All nice things, but definitely needing consequences. Mr. Mandalis actually asserts that the aspirational goals benefits the move-ins and the move-ins did not show how they were harmed by them. He finally acknowledges understanding our point on enforceability, but he quickly reiterates that the code does not preclude them. So we have another instance of the no harm, no foul discretion on the part of the Planning Commission in its final act on the clear space and spotlight applications. The only thing missing before the, thank you. The only thing missing before the curtain call was for the Planning Commission to ask the applicants to stand, raise their right hands, and promise to do their best. In conclusion, due to the numerous process issues with how the Planning Commission did not properly execute its responsibilities as defined by city code and or guidance from the state, the move-ins asked that the Planning Commission's approvals of these two applications be overturned and at a minimum remanded to the Planning Commission for a proper by the code redo. Thank you.
You'll have a minute and 30 seconds, a minute and a half. on
Wow.
rebuttal. Okay?
Thank you.
Thank you.
I'm going to respond on behalf of.
All right, we'll now go to Mr. Mandalis and Mr. Lawson.
Thank you, Mayor. I'm having a hard time hearing myself with masks, so I'm going to put it down for just a minute. I'm going to very briefly respond to this because I believe there was a lot of attention paid to how this affected the public, and I wish to point out that 21 people does not represent the public. And there are, in fact, from my understanding, although I haven't seen a petition of more than 250 signatures on it, that you will fairly represent the public. Public's position is not taken into account here, and in fact, the public's position will be tainted and hurt by a decision in favor of this because ClearSpace is dependent on grants and donations from nonprofit agencies, and its time is running out, and pretty soon it will not be an argument about whether or not to have the theater. There just won't be one. And in that regard, I will respond. I did ask for expedited review originally because of the nature of getting applications for grants in, because they had deadlines which are coming up, in fact, at the end of this month. With that, I'll turn it over to Mr. Mandalis.
Thank you, Mr. Lawson. Before I start, are there any questions for Mr. Lawson? Thanks. So let me make a couple.
Can you hold a minute? Stop the clock. Ann Womack has her hand up.
Excuse me for the interruption, but is there any way possible that Attorney Mandalis and Lawson can move the microphone closer to them? It's very hard to hear them.
There actually is not. Are you having difficulty hearing me?
Not so much you, but I did have difficulty with Attorney Lawson.
Yeah, the microphone is literally on the monitor. We may be able to move the monitor closer when he speaks, but if you can hear me okay, I'll proceed. And when he goes again, we'll try to make some accommodation.
Okay, great. Thank you.
Thank you, Ann. The clock was stopped, and it will now be restarted.
Thank you. So I'm typically sitting with the commissioners as the city solicitor. I'm not today, as you all know. I am representing the Planning Commission, and while I may be in the room with Mr. Lawson, I don't represent ClearSpace or Rehoboth Spotlight. So to be very clear, that my position today is in protecting the integrity of decisions of the Rehoboth Beach Planning Commission. It's not about, as Mr. Walton said, whether this planning commission likes clear space or doesn't like clear space or spotlight. It's more about protecting the integrity of a decision that the planning commission has made. Frankly, I think there's been already too much time spent on these motions, so I'm gonna go much more quickly than Ms. Hatchovich did on this motion. And this first motion that we're addressing today is largely about, and you'll see it as a theme through many of the motions that the appellants have filed. It's largely about the city kind of overperforming and then getting that held against them. So let me start with the first one, which is this improper notice that they, and everything in this motion sounds like it's a conspiracy. The city's conspiring somehow. Nothing could be further from the truth. This improper notice, for example, I don't know if you read it in my papers. I'm sure you did, because I know you're all students of the information that's provided to you, and you read up on it. But as I mentioned in the motion, this was a notice that never needed to get published. There was no legal requirement to do it. There is no need for it, other than the city tries to overperform and publishes notice even when it's not required. So there isn't, but to be clear, there is no notice requirement for this public meeting to be published in a paper. There was a notice requirement that it be put on the city's board in City Hall. But the publication that was made was the city overperforming and now it being held against them for doing it. Move on to the setting of the public hearing date. Again, this seems to be a lot to do about not so much. In a perfect world, I agree. You would take the materials in, see that it's all correct, adequate, and ready to go to a public hearing. But as the commissioners know, there have been times when the commission itself has scheduled a public hearing before it has finished up its workshop duties as a matter of efficiency. And to the extent that the next workshop, everything is satisfied, they go forward with the public hearing. But just as the commission could choose not to go forward with a public hearing if it didn't obtain all the information it needed, the planning commission could have done the same thing. So when it got to the public hearing, somebody could have said, hey, we got in the additional materials that we asked for. I don't think they're adequate, so let's not go forward with the public hearing. That didn't happen. Even the two members of the planning commission who voted no on these applications didn't feel that the information wasn't sufficient to go forward with the public hearing. So again, the planning commission trying to work efficiently seems to be somehow something to be held against them. The issue on inadequate time to review. You all are aware, I think, of the way that the city secretary deals with materials that come into her office. She works diligently at loading materials as soon as she gets them. And that's the same way she handled this application. When materials came in, she would load them as quickly as she had them. And the thought that somehow there was inadequate time to review or the materials weren't available. I mean, you see how resourceful the appellants in this matter are. They produced more paper in a matter of just a few short days and done more research on more individuals on the planning commission and on the commission. The time to review, was adequate in my view. It was interesting that we skipped over the suppression of public comment issue in this motion. As you know, they complained there about the 2-day sign up and the ability to talk contemporaneously. Well, just a couple of days ago, an AG opinion issued as related to the city. And that AG opinion, of course, found that the process the city uses is entirely appropriate. So there was no reason to address that one because there's an AG opinion saying that the appellants are just incorrect on that matter. Finally, there's the argument about the delay in issuance of meeting minutes for July 10 and August 14. Again, I don't mean to keep praising Ann Womack, but you all know that Ann works diligently on getting meeting minutes out, and there's no intention on anybody's part to delay meeting minutes for any reason whatsoever. This is just simply an issue that never even should have been raised. Ms. Atkovich asked about the July 18, and whether there was an illegal meeting. It's the first time I'm hearing of, did the planning commission meet illegally? There was no meeting on July 18. None of that occurred. I'm not sure, where that allegation really comes from. Let me see what else she raised. So again, there's a lot about how much material was available to the appellants and at what time it was available. Again, I feel as though the city has one of the most robust systems for providing materials to the public. I mean, I work in a lot of jurisdictions, and I don't know of a system that allows for the foldering that Ann does and the level of detail that's placed and uploaded. So the argument that documents weren't available timely, I just don't buy it. And I don't think you should either. On the legibility of the plans and this tree issue that came up, to talk about one of the biggest projects to be built in the city, and we're down to the detail of a tree on the property. It seems like there should be something larger than that to make it, to send this back to the planning commission or to reject it entirely. And let's be clear. This is in the commercial district. There are no setbacks, but for the buffer between the residential district behind these lots, the 5-foot buffer, there are no setbacks required. So it is true that a commercial developer who is developing those lots would be able to develop those lots to the lot lines, and trees would be removed. Our comprehensive tree ordinance does not have a minimum tree density for commercial lots. So with that, as I said, I think there's just been a lot of time spent on these motions already. I know you've read them all. If there are questions for me, I'm happy to answer.
Can we entertain questions?
Sure.
The commissioners have any questions for Mr. Mandalis or Mr. Lawson? Seeing none.
One minute. 30.
Right. The appellants have 1 minute and 30 seconds left on their time for rebuttal. Marie?
Thank you. I'd like to make a quick comment. We in no way blamed the city secretary for the delay of documents or the delay of the minutes. What we said was that the minutes needed to be out in a timely manner that would allow us to be responsive citizens. If that was going to be an issue, the public hearings should have been moved farther away. But I do want to make an important point here. I would ask that the remarks about the petition that Mr. Lawson brought up be struck from the record. It is inappropriate for this to be referenced in the record, and we aren't prepared to address it on the merits. However, please know that we have no doubt that those folks who signed the Save Clear Space petition are sincere in their concern for keeping clear space in Rehoboth. Honestly, although the appellants are too. But of those 227 people who appeared as signees in Tuesday's Cape Gazette ad, it's important to note that only 13 households signed that are actually within the area that will be most affected by the problems of parking, traffic, safety, and such, which will happen if this project is built as it's now designed. A conservative mapping of that area covers Grove Street to 3rd Street and Henlopen to Sussex. The impact, of course, will be even broader than that. But those 13 households that signed the petition represent fewer than 6% of the 225 homes in that high impact area. The bottom line is that it's important to understand and recognize that the folks who will be most affected by this project are not represented in any meaningful way by the petition. But I do ask that the comments be stricken from the record because they're not appropriate.
Marie, your time is up. Thank you very much.
Thank you, Mayor and Commissioner.
Hold on. Let's hold on. Before we get into discussions, do you have a general question, Commissioner Calusi?
I do. Thank you. This is addressed to Mr. Walton. It appears to me that Ms. Hatkovich was really talking about the merits of this case. Should her remarks be stricken as well because she was talking about things like parking, et cetera? Can you address that for me, please?
My view is that we shouldn't be striking and doing all of those things. We need to decide the motions that are in front of us. If I felt that it went too far into the merits, obviously I've provided leeway to both sides. I did so in both instances on sort of the merits and things that weren't necessarily in the record. But in fairness, I don't think we need to take that up. I think we need to answer the questions that are presented in the motion and without getting struck and what doesn't at this point, right? We're focused on the merits, and if the merits come up, you can't decide it based on the merits. You have to decide it based on the questions that were presented in the motions. So my advice to commissioners would not be to entertain any motions to strike or anything like that, and to answer the questions that were submitted in the motions.
Thank you.
All right. Thank you very much. At this time, the commissioners have time to entertain motions and discussions and votes. If you recall, our process number one is that all motions are in the affirmative, and that when we do give our votes, that the reasons for our vote need to be articulated. Also, you'll recall last time that we offered, I entertained and you all offered a motion first, and then that led to discussion, culminating in a vote. So at this time, we have the first of the 8 motions to look at. I would entertain a motion relative to the newspaper notice.
Commissioner, you're on mute.
You're muted, Ed.
Sorry about that. Mayor, I move to remand the matter to the Planning Commission due to the fact that the newspaper notice stating public hearing rather than public notice was improper and misleading.
Do we have a second?
Second.
We need a second.
Second.
Okay, we have a motion and seconded to remand the matter to the Planning Commission due to the fact that the newspaper notice stating public hearing rather than public notice was improper and misleading. Discussion, please. Well, I'll offer that I'm going to vote no to this. I believe that it was a technical error and that in legal terms it was harmless, and therefore I will vote no for it. Are there any other commissioner comments? If not, I'll call the question. And remember, we need to give a rationale or reason. You can tag on to the previous reasoning if you like. Commissioner Byrne.
Commissioner, you're on mute.
You're on mute.
There we go.
There you go.
Sorry about that. Thanks, Mayor. I vote no. I don't believe that the newspaper notice provided for in the hearing it was at all misleading.
All right, thank you. Commissioner Calusi.
I vote no for the reason stated by Commissioner Byrne.
All right, Commissioner Czerniawski.
I vote no for the reasons stated by you, Mayor, and Commissioner Byrne.
Commissioner Gay.
I vote no, Mayor, for similar reasons to, that you stated, but also while I do believe there are a number of confusing issues, and this is one of them, it doesn't rise to the level of a remand on this basis alone.
Thank you, Commissioner. Commissioner Gossett?
Yes, I also vote no, as I feel that public notice is very important.
And it may not be outlined in the code specific, but it has been our common practice to provide this information. I don't think it rises to the level of remand.
Thank you. Commissioner Legree?
I vote no, and I will incorporate the comments of Commissioner Gossett.
And the chair votes no for the reasons I articulated earlier. Therefore, a unanimous no vote, and the motion does not carry. Thank you very much. We'll go on to the second motion we want to entertain, and that's relevant to improper placement of the matter on the agenda and the timing. Can I get a motion in the affirmative, please?
Mayor, I would move to remand the matter to the Planning Commission due to the improper placement of the matter on the August 14th agenda as of July 11th, prior to the applicant addressing all of the issues as required by the Planning Commission.
And do we have a second?
I second.
And we have a second by Jay. We have a motion by Commissioner Gossett and a second by Commissioner Legree, moving to remand the matter to the Planning Commission due to the improper placement of the matter on the August 14th agenda as of July 11th, prior to the applicant addressing all the issues as required by the Planning Commission. Open it for discussion.
Yes.
Commissioner Gay?
Yeah, first of all, this one is a concern to me because I think it goes to the very heart of site plan review. And the first thing I'll say is in our code, there's no such thing as an expedited review. And the sort of irony of that and I think maybe that's where this got off the rails in the first place. But the irony there is that the review process, when it's followed according to code, is really not all that long. There haven't been all that many site plan reviews since this code went into effect. And in each of the others, as an example, the very complicated school project, the preliminary review was done in June and it was all approved in September. So 3 months is not long. The same with the Avenue Inn may have been even shorter, and that's a similar same size lot to this application. So one of the really unfortunate things is if the procedure had been followed according to code, they'd be done by now. They would have been done probably in October. And so it really is unfortunate, but it's true that the public hearing cannot be scheduled according to code until it's determined that no additional information is needed and that there are no outstanding legal issues. And in fact, the building inspector raised a legal issue. He said at the meeting, there is still an issue outstanding. And it needs to come back for review and approval. And I'm not going to get into the merits here, but in addition to that, the code lists 26 elements of the site plan, and it lists 21 factors, including access to streets and lighting and drainage and scale and many other concerns that weren't specifically addressed. The code review that people refer to when they say it's code compliant actually only looked at about 6 factors. So the fact that, and those were zoning code issues, and some of them are compliant. So, but the site plan review is also part of the code. It's an important part of the code. And, I don't think that was followed. So I'm not sure we can say it was code compliant. It was partially code compliant, but in a way that's like being a little bit pregnant, I think. So, but
I don't mean to interrupt. I just want to focus on the motion at hand right now.
Right. Well, so I'm saying that I don't believe that it should have been, again, based on the code and also based on how it's been applied in other site plan applications, should not have gone to public hearing based on the.
Any other commissioners? I will state that the Planning Commission obviously has rules to follow, be it in their own bylaws or state or city code. And I do believe in this matter, they violated their rules, so I will be voting yes. Any other commissioners' comments? If not, I'll call the question. This is a motion to remand the matter to the Planning Commission due to the improper placement of the matter on the August 14th agenda as of July 11th, prior to the applicant addressing all the issues as required by the Planning Commission. Commissioner Calusi?
Yes, I'm going to vote no for the reason that I believe there's been a precedent in the past where this has happened, and I feel that it would be somewhat unfair to vote yes on this because I believe at this stage it's really a harmless error. So I'll vote no.
Thank you. Commissioner Sernowski? Unmute yourself.
My apologies, the dog started barking. I'm going to vote no, and I'll incorporate Commissioner Calusi's comments, as well as the Planning Commission itself could have said that it didn't have, the issues were not addressed at the time of the public hearing, and they could have deferred it, which we do as a Board of Commissioners all the time, schedule public hearings and then defer it. So for those reasons, I vote no.
Thank you. Commissioner Gay?
I vote yes for the reasons I stated earlier, and also because I do believe it's important to protect the integrity of the Planning Commission, and this is their process, and I have never seen it done any other way.
Thank you. Commissioner Gossett?
Yes, as being a former member of the Planning Commission, I am extremely familiar with the process and how it has been followed in the past years. And it is outlined specifically in the code. The city code states that the applicant who has addressed these issues, if any, identified at the preliminary hearing shall have its site plan placed on the preliminary commission's agenda. It's 236-32H. Here, on July 11th, the applicant was told to further address some issues, so the issues were not addressed as of July 11th. But the Planning Commission therefore added the site plan review on August 14th agenda before receiving the additional information requested. The appellants are further correct that the site plan application instructed sheet found on the city's website, which I happen to be an author of, does provide that until it is determined that no additional information is needed, there are no additional legal or factual issues needed clarification, that the Planning Commission may not move the application forward to a public hearing. Moreover, reading the code and site plan application formed together makes clear that the application should not have been placed on the agenda for a hearing until the additional information was received. For that reason and the others, I am voting yes to remand.
Thank you. Commissioner Legree?
For the reasons stated by Commissioner Gay and Commissioner Gossett, and for my own reasons, which I believe that the Planning Commission, the integrity of the Planning Commission is vital to the citizens of Rehoboth Beach. They represent us. We count on the Planning Commission to perform due diligence. And if the Planning Commission doesn't perform due diligence, who in the heck can we trust? So in addition to the remarks by Commissioner Gay and Commissioner Gossett, I vote yes to remand.
Thank you. Commissioner Byrne?
I vote no and incorporate the comments from Commissioner Calusi and Szyrzynowski.
Thank you. And the chair votes yes for the reasons he stated earlier, as well as incorporating the responses from Commissioners Gay, Legree, and Commissioner Gossett. With that,
Before we move on, Mr. Mayor, I
Yes.
request a short recess.
all righty. With that, that motion does carry. We're going to hold a short recess, undetermined time, but won't be very long.
It'll be less than 5 minutes.
Less than 5 minutes. Thank you. We're back on the record. Want to state that with this last motion, we have voted to remand the matter. And because we have voted to remand, the remaining issues presented in the process motion do not need to be decided. Similarly, the remaining motions relative to ineligible members, conflict of interest, site visits, community meeting motions also need not be decided, again, because we have already remanded this matter to the Planning Commission for a new public hearing. Consequently, there's nothing further to consider, and the meeting is adjourned. Thank you very much.
May I ask a question?
Sure, go ahead.
What are we being, for what purpose are we being remanded? The only thing that the commission has determined is that the public hearing was scheduled sooner than it should have been under the city code. So with that determination, presuming all the material the planning commission has what it needs, based upon what the commission decided, I think a public hearing is what we're being remanded to conduct.
It would be for a new public hearing.
Thank you.
Oh, I've adjourned it, and yet somebody has a question.
I don't know that we got right to adjourn, because, go ahead, I would answer the question.
Okay, we'll keep the meeting going. Commissioner Gay?
You're on mute.
You're on mute.
Yeah, I have a question about sort of exactly what we were remanding also, and whether or not we could put conditions on this, because, and let me explain why. First of all, you know, this motion process is not in the code. So even though the code gives us the right after an appeal hearing to remand it for a public hearing, we're in a totally different process. And the motion that we voted on was all about the preliminary, the problems, you know, going from the preliminary hearing prematurely to public hearing. So in my view, it should start back at that stage, because otherwise we're just going to be in a vicious circle. It's going to come again. So do we have that option to state conditions, or to state in more detailed fashion what we're remanding for?
I don't believe so, because we never got to the merits. And so ultimately, the motion that you approved, you said, look, it was really related, what you voted to remand on was for the improper placement of the matter on the August 14th agenda without addressing all the issues, okay? And there was a process defect that went in. So this is a preliminary motion. It's not like we're dealing with this after we got all the way through the process and got to a merits hearing, and then we remanded on that point. So what you've decided is there's a defect in the process, right? So that has to go back to the Planning Commission for a hearing, and then that has to be cured, and then the record will be set based upon the Planning Commission at that time. So it's a new public hearing.
Right, but that's my point, that there are considerations for process. I'm not getting into the merits. I'm just saying that there are a number of considerations related to process.
There may be other considerations, right? I'm just trying to deal with the motion in front of us. Any other thing that we did, if we went through all the other motions and we made a comment on them, would be moot, because it would have to be a new public hearing. As and when that public hearing is ultimately heard, some of those process things very well may be cured before the Planning Commission. So I don't know that we need to hear them or sort of remand with those conditions. It is a new public hearing. I'm trying to stick to what, in other words, we made a motion, right? We said that the agenda functionally was wrong. That entitles the applicant to go forward with a new hearing, right? To hear that particular issue, or to hear that issue, or to make whatever presentation. At a new public hearing, there would be new process things that would come about. So I don't think we ought to, in this particular, ma'am, I will call on that. I just don't think in this particular instance, we ought to place conditions beyond what we voted on. And I'm doing this on the fly, and that may or may not be right, but that's what I think is the right thing to do in this circumstance.
You know, and I'm just getting it to how to make it most efficient because I don't want it to be circular again and to come back to us. I'd like to be able to give some direction, process direction, mind you, but direction nevertheless, just to to clarify, if nothing else, what we're really asking for.
Understand, but when you're here to act in an appellate capacity.
Right.
And it's their job to make the process and to make the process satisfy the requirements of due process and the requirements of the code. And presumably that will be taken care of on a remand. So because we didn't reach the merits, I don't think it's really proper to remand with conditions at this time. And I'm sorry, Marie, I didn't go to you. I know you had a question. Or had your hand up. And I need you to take your mic off.
Take my mic
Go
off.
Or no, you were on mute before.
It's
I can hear you now.
my fellow appellant, Harvey Schulman, would like to be recognized, if you would, please. With a question?
We've also got Commissioner Gossett.
Let's let Mr. Schulman go. Mr.
Schulman would be fine.
Thank you.
He wasn't identified as a speaker.
Thank you. Can you hear me?
Yes, sir.
Okay, I have one question. I agree a lot of what's left is moot. What I'm not sure is moot, and I would ask council to consider this. One of the complaints was site visits, and this is going to go back. We really need some guidance. I think the Planning Commission needs some guidance on these site visits. Otherwise, we will get back into this cycle again about who visited, who didn't. Can people still go to visit? This is something that's different from all of the other aspects of these dispositive motions.
I do not think it's proper to consider that motion because it is ultimately moot. The Planning Commission has counsel. Counsel can guide them on those issues.
Well, council was there the first
Whether or
time.
not you think they got it right or not, that's council's motion. So the issue that we voted upon here, ultimately, the issue that we voted upon ultimately, or the commissioners voted upon ultimately, was to remand the matter relating as of July 11th, or excuse me, remand the matter based upon the improper placement on the agenda. Again, if it goes back and there were other process issues, if there's a new public hearing, those process issues may be cured. So, Mr. Mayor, it would be my recommendation to not take up that motion because I think it would be improper.
Thank you.
Okay, I hear you. And also, Mr. Walton, just for the record, there was a request that Commissioner Chrzanowski recuse himself. You told us.
Yeah, we're not going to take that up either, as I told.
Yes, I know. I understand, but the public doesn't know that. So all I'm saying is that was filed, and you
improper. That was I already made a determination upon that, and that will not be discussed. And that was stated very clearly. That will not be discussed.
I'm not discussing it. I'm just preserving it for the record.
So your record is made. Thank you.
Thank you. Thank you.
Thank you.
One question.
Yes, sir. Commissioner Gossett?
Yes, remanding this back for a public hearing. I understand that. Will this be de novo?
That's my question.
It will be a new public hearing on the subject matter of the application. Yes. So
In a preliminary hearing, the merits, or not the merits, but the issues are reviewed. I don't understand, I'm just trying to be clear here. If we have a de novo public hearing, where are those facts gathered for the public hearing if we do not have a preliminary hearing?
You've already had a preliminary hearing in this matter. And the issue was ultimately that you voted on was that the final hearing, or the hearing, the items, there was things that were requested by the Planning Commission. And there's things that were requested by the Planning Commission were not satisfied prior to the actual hearing. So there's, as it stands right now, those things would be satisfied, and there would be a new public hearing based upon the record that was there before. I think I'm going a little bit out of turn here, because a little bit of that's going to need to be dealt with by the Planning Commission, and I am acting a little bit on the fly, so please excuse me. But ultimately, there was a preliminary hearing. That preliminary hearing occurred, you said, and ultimately your determination is that as of that preliminary hearing, you didn't have all the information. Now they have all the information that they should have had, there'll be a new public hearing.
But the public hearing then is de novo or on the record?
The public hearing would be based upon I'm not sure that I understand your question, but it would be based upon the preliminary hearing that occurred before, and then the planning commission would hear all of the evidence again.
All of the evidence that was already presented. Now, there was some discussion of that July 18th meeting of additional materials that were presented. So those would be included in the public hearing?
I would have to leave that to the attorney for the planning commission, but yes, I believe that would be the case.
All right, thank you.
Thank you. Any other questions from the commissioners? If not, I thank you, and this meeting is now formally adjourned at 11:11 a.m. Thank you very much.